Okay, so I want you to picture a scenario with me. It's a Tuesday night.
Mm.
It's raining. You're sitting at your kitchen table. Maybe you've got a lukewarm cup of tea, and you're looking at a pile of papers, insurance policies, bank statements, that sort of thing.
Hmm.
And suddenly you get that feeling. You know the one I'm talking about.
Oh, I know it well. That heavy, sinking feeling in the pit of your stomach.
Exactly. That dread that whispers, oh, I really need to get my affairs in order. It's the ultimate adulting nightmare.
It
But
is.
then you immediately picture the alternative. In our heads, fixing this means making an appointment with a lawyer in a high-rise downtown, sitting in a mahogany office that smells like old leather and billable hours.
And listening to someone use Latin phrases you haven't heard since high school.
Right. While the clock on the wall is audibly ticking away hundreds of dollars an hour, it feels expensive, it feels morbid, and honestly, it just feels impossible for a normal Tuesday night. So what do?
You put the papers back in the drawer.
And watch Netflix.
It feels like a massive barrier, and that barrier is exactly what we are taking apart today. We are doing a deep dive into a platform called ClaimMyLegacy.com,
Okay.
and the promise they are making is huge. They are essentially claiming to be the TurboTax moment for estate planning.
That is a bold comparison. I mean, TurboTax changed everything because it took a complex government code and turned it into a yes or no wizard. But filing taxes is just math. It's numbers and boxes.
Right.
Estate planning is your life's work. It's your children's future. It's the house you build. The idea that software can replace the family attorney, well, honestly, that makes me a little skeptical.
And it should. Skepticism is the right approach here. That is the mission of this deep dive. We aren't just reading their marketing brochure. We are looking at their technical specifications, their legal structures, the actual documents they generate, and the testimonials to answer one question. Can an algorithm really replace the mahogany desk?
Before we get into the tech, though, we have to look at the stakes. Because I think a lot of people listening might be thinking, well, I don't have a plan, but nothing bad has happened yet. I'm healthy, I'm youngish, can't I just wait?
And that's the dangerous comfort zone. The source material leads with a statistic that is, frankly, terrifying. The majority of Americans have absolutely no estate plan in place.
At all.
Nothing. Zero.
Why do you think that is? Is it just the cost? Or is it that we just hate thinking about dying?
It's cost, sure, but it's also psychological avoidance. We don't want to confront our own mortality. But here is the reality check from the research. If you don't have a plan, the government does, and it will cost you.
I hate the sound of that. The government has a plan for you.
That sounds like a threat. In a way, it is. When you die without a plan, which in legal terms is called dying intestate, the state steps in. They have a default one-size-fits-all flowchart for who gets your stuff. And as you can imagine, government efficiency isn't the gold standard here. It's slow, it's rigid, and it often distributes your assets in ways you would never, ever choose.
Give me an example. What does the government plan actually look like?
Well, every state is different, but generally it follows a strict bloodline hierarchy. It doesn't care if you haven't spoken to your brother in 20 years.
Oh.
It doesn't care if you wanted your stepchild, who you raised but never adopted, to have the house. If the chart says sibling, the sibling gets it. The state just doesn't do nuance.
So you're saying that by doing nothing, you are actively choosing the government's plan. You're letting a flowchart decided by a bureaucrat determine the future of your family.
Exactly. You are defaulting to the state's plan.
Okay, that's sufficiently sobering. Let's pivot to the solution this platform is proposing. They keep using this analogy to tax software. Millions prepare and file taxes online. Now you can prepare your estate too. How does that translation work? Because law isn't just numbers, it's language, it's intent.
This is where the user experience design comes in. They have moved entirely away from the concept of filling out forms. You know the nightmare scenario staring at a blank PDF line asking for the party of the first part?
Or per stirps versus per capita. I have no idea what those mean, and if I saw them on a screen, I would close the laptop immediately.
Exactly. If you see those words without context, you quit. Claim Your Legacy uses an interview methodology. Think of it as a logic tree. It asks you plain English questions. Are you married? Do you have children? Who do you want to inherit the house?
So it's conversational. It feels more like a chat than a legal exam.
It is. The system takes your answers and maps them to the legal clauses in the background. It uses pop-up help to explain concepts in real time.
So instead of me needing to know the legal definition of a successor trustee,
Right. The system explains, this is the person who will manage the money for your kids if you can't, and you just type in a name.
I appreciate that they explicitly mention hating legalese. They call it an unneeded barrier, which, thank you, finally. But let's talk about speed. They claim you can be printing your plan in about an hour.
That's the benchmark they set.
An hour. That is faster than watching a movie. That is faster than my commute. Compare that to the traditional route for me.
Well, the traditional route is call the firm, wait 2 weeks for an appointment, drive there, have the intake meeting, wait 3 weeks for the draft, go back for revisions. We are talking months. Collapsing that into 60 minutes is a massive efficiency leap.
But here's the devil's advocate question. Efficiency is great, but is it cheap? If these are real legal documents that stand up in court, shouldn't they cost thousands of dollars? Is this a you get what you pay for situation?
That's the fear, right? But this is the economic argument of the TurboTax model. In the traditional model, what are you paying for? You are paying for the lawyer's time. You are paying their hourly rate for every minute they spend typing your name into a template.
Right, the billable hour, the lawyer's mortgage payment.
With Claim Legacy, they have front-loaded that cost. They paid expert estate planning attorneys thousands of hours upfront to draft the master templates and build the legal logic into the code. Once that code is written, the marginal cost of serving one more customer is, well, it's basically zero.
It's economies of scale.
Precisely. Whether one person uses the platform or 10,000 people use it, the hard legal work is already done. You aren't paying for a lawyer to type. You are paying for access to the logic the lawyers built. That's how they crash the price without crashing the quality.
Okay, so the logic holds up on the how. Now I want to get into the what, because the sources make a very big deal about the difference between a will and a trust. And I think this is where most of us get lost.
This is probably the most critical part of the deep dive. If listeners take away one thing, it should be this distinction.
Most people assume I write a last will and testament, I put it in a safe, and I'm good. But the source material calls the government plan, and the plan relying solely on a will, slow, expensive, and completely public. That last part, completely public, really jumped out at me.
It should. This is the reveal that shocks most people. A simple will is not a private document.
Explain that. If it's in my safe and only my spouse knows the combination, how is it public?
It's private while you are alive, but the moment you die, for a will to be effective, it must go through probate. Probate is the court process of validating the will. You have to file the will with the county court. Once it is filed, it becomes a public court record.
Wow. Wait, so anyone can go to the courthouse and see it?
Anyone. And in the digital age, anyone means data scrapers, marketers, and scammers. The source warns that this complete loss of privacy often attracts unwanted attention. Imagine a scammer looking up recent probate filings, seeing that your grandmother left you $50,000, finding your address, and then targeting you with investment opportunities.
That is terrifying. I didn't even think about the safety aspect. I just thought privacy meant I didn't want my nosy neighbor knowing who got the antique china set.
It's both. It's nosy neighbors, it's distant relatives coming out of the woodwork, and it's legitimate predators. And aside from privacy, probate is expensive. The court fees and attorney fees to get a will through probate can eat up like 3 to 8% of the estate's value.
8%. That's a huge chunk of money just to get permission to give my stuff to my kids. So the solution they propose is the revocable living trust. How does that fix the privacy issue?
A trust is fundamentally different. A will is a letter to a judge. A trust is a private contract. When you set up a revocable living trust, you are creating a legal box to hold your assets. You move your house, your accounts, your life into that box.
I still control the box.
Completely. That's the revocable part. You can change it, break it, empty it. It's yours. But, and this is the magic trick, when you die, the box doesn't die. The box already owns the assets, so you don't need a judge to transfer ownership.
The box just gets a new manager.
A new trustee. Exactly. Your successor trustee steps in, follows the instructions you wrote in the private contract, and distributes the assets. No court, no judge, no public record.
So nobody knows who got what?
Nobody but the people involved. It stays completely off the government radar. That is why Claim Legacy emphasizes the trust as the core of the plan. If you only have a will, you are signing your family up for court. If you have a trust, you are giving them a private transfer.
Okay, so the deep dive secret here is, if you want privacy, a will is not enough. You need a trust. But in looking at the list of documents they provide, the stack. And it's not just the trust. It's pretty extensive.
It is a comprehensive estate plan. They aren't just selling you the one document.
I see last will and testament on the list, too.
Wait.
Wait, didn't we just say the trust replaces the will? Why do I need both?
Are
Are they trying to upsell me?
No, it's a safety measure. In this context, it's called a pour-over will. Think of it as a safety net. Let's say you set up your trust, you move your house into it, you move your bank accounts into it, but then 2 years later, you open a new savings account and you forget to put it in the name of the trust.
Which I would definitely do. I forget passwords daily. I will definitely forget to title an account correctly.
Yeah, would. If you die with that account outside the trust, the pour-over will kicks in. It basically tells the judge, hey, look, he forgot to put this in the box. Please pick it up and pour it into the trust for him.
Ah, okay. So it catches the stragglers.
Exactly. It ensures nothing gets left out in the cold.
Moving down the stack. Financial power of attorney and healthcare power of attorney. Those aren't for when I'm dead, right? Those are for when I'm still here.
Yes, and honestly, these might be more important than the will. Estate planning isn't just about dying, it's about incapacity.
Incapacity.
If you get into a car accident and you're in a coma or you develop dementia, like, who pays your mortgage? Who authorizes your surgery?
I just assume my spouse does. Or my parents.
Not necessarily. Privacy laws like PUPA prevent doctors from talking to people who aren't authorized. Banks will freeze accounts if the owner is incapacitated. Without a power of attorney, your family might have to go to court and sue for conservatorship just to access the checking account to pay the electric bill.
That sounds like a nightmare on top of a tragedy. You're dealing with a loved one in a coma, and you have to sue them to pay the lights.
It is a nightmare. These documents, the powers of attorney, the living will, the advance directives, they are the in case of emergency kit for while you are still alive. They answer the hard questions now. Do you want life support? Do you want tube feeding? Answering that now saves your family from having to guess or fight about it in the hospital waiting room.
There are a couple of terms in the feature list that sound a bit more technical. I want to decode them. Spendthrift provisions. This sounds like something from a Victorian novel.
Yeah.
Whoa, young Master Edward is a spendthrift.
It does, doesn't it? But it's a modern superpower. Spendthrift, in legal terms, refers to protecting a beneficiary who might not be good with money or who is in a vulnerable position.
Give me an example.
Okay, imagine you want to leave money to your son, but maybe your son is going through a really nasty divorce, or maybe he has a lot of credit card debt, or maybe he has a gambling problem.
If I just give him a check for $100,000.
His creditors can seize it immediately. His ex-wife's divorce lawyer can go after it. The casino gets it.
Right. And then he has nothing.
A spendthrift provision locks the vault. It says the money is for him, but it remains inside the trust. The trustee can pay his bills directly, buy him groceries, pay his rent. But because the son doesn't technically own the lump sum, his creditors can't touch it.
So it protects the inheritance from the beneficiary's problems.
And sometimes protects the beneficiary from themselves.
That is smart. What about IRA look-through? That sounds like tax jargon.
It is, but it matters. Retirement accounts like IRAs have specific rules about how fast they have to be cashed out after you die. If you just dump an IRA into a generic trust without the right language, the IRS might force your kids to cash it all out in 5 years and pay massive taxes immediately.
Ouch. So the government gets a huge cut right off the top.
Exactly. The look-through language allows the trust to look through to the beneficiaries, effectively treating them as individuals so they can stretch those tax payments out over 10 years. It preserves the tax-deferred growth. The fact that this software handles that automatically is actually pretty impressive. It shows there is real legal logic running in the background, not just a text editor.
And that leads to another big selling point, flexibility. They mention unlimited funding letters and unlimited changes. Why is the unlimited part so important?
Because life isn't static. In the old model, estate planning was treated like carving a stone tablet. You did it once, you paid your $3,000, and you hoped nothing changed. But families change. You have another kid, you get divorced, you buy a vacation home.
And in the old model, every time that happened,
You called the lawyer and the meter started running again. $500 for a phone call, $1,000 for a draft. It discouraged people from keeping their plans up to date. Here, they offer unlimited changes and unlimited restatements as long as you have an active account.
it shifts the mindset. It's not a one-time event. It's a living document.
Exactly. If you buy a new house, you just log in, generate a new funding letter to transfer the deed to the trust, and you're done. No billable hours.
Okay, I have to play the skeptic now. We are talking about life savings.
Yeah.
We're talking about critical data, social security numbers, asset lists, and we are typing this into a website. Is it safe? I get nervous just buying shoes online sometimes. If this database gets hacked, they have everything.
It's the natural question. Skepticism is healthy here. The source addresses this head-on with their security section. They list specific technical standards. SHA 256 RSA, 4096-bit keyed SSL encryption.
Translate that for me. Is that good, or is that just marketing fluff?
It's bank grade. It's the same level of encryption your bank uses to protect your checking account. They also mentioned that data is encrypted in transit and at rest.
At rest means even when it's just sitting on their hard drives.
Right. Even if someone physically stole their server, they couldn't read the data because it's scrambled. They also cite an A rating from independent SSL labs. So from a cybersecurity standpoint, they are checking the right boxes.
What about the legal safety? It's software. Can a computer actually practice law? If the document is wrong, who do I sue? The robot.
That's the distinction. The software isn't practicing law. The documents were drafted by expert estate planning attorneys. They clarify that they've combined technology experts with legal experts. The templates are compliant in all 50 states. It's a hybrid model.
So it's human expertise delivered by a digital interface.
Yes, you are getting the lawyer's brain, just not their bedside manner or their hourly invoice.
Speaking of bedside manner, I want to talk about the human side of this. Because all this talk of encryption and revocable trusts, it can feel cold. But the testimonials in the source material tell a different story.
Oh.
These aren't just reviews about ease of use. They are emotional.
They really ground this. Take Tiffany from Arizona. She's a single mom. Her testimonial is heartbreakingly real. She says she was worried my kids would be sent to foster homes if something happened.
Oh, wow. That hits hard. That's a primal fear.
It is. For her, the affordability wasn't just about saving a few bucks. It was about access. She couldn't afford the mahogany desk lawyer. If this platform didn't exist, she would have had nothing. This gave her peace of mind that her children would be in a good home. That's not just paperwork. That's protecting your family.
And then there's Steve E. from Virginia. His story is about his dad.
Right. His dad had a plan in place before being diagnosed with Alzheimer's. Because he did, the family's transition was easier. They knew how to honor him. It highlights that this isn't just about money. It's about reducing emotional stress during a tragedy. When you are grieving, you don't want to be fighting with a court clerk. You want to be with your family.
There is one testimonial that surprised me, though. A. Clark. They mentioned a unique problem.
Yes, and they praised the support team for finding a solution. That's important because it suggests there are actual humans behind the software. It's not just a faceless algorithm. If you get stuck, there's a local estate plan coordinator or support staff to help navigate the platform.
Now, here's something I found a little weird. I went to the How to Buy section in the source, expecting a big orange Add to Cart button, but it's not there.
It is a bit unusual for an online service, isn't it? The source says, to make a purchase on this site, please use the link provided to you by a licensed financial professional.
Yeah, investment advisors, insurance agents, banks. You basically have to be invited, or at least sent a link.
You can request info if you found them via search, but the primary model seems to be B2B2C, business to consumer.
Why do you think that is? Why not just sell it to everyone directly like Netflix?
I think it connects back to the idea of holistic planning. Estate planning shouldn't really be an impulse buy at 2 in the morning. It fits better as part of a broader financial strategy. Your financial advisor knows your assets, they know your goals, so it makes sense for them to facilitate the estate plan that protects those assets.
It positions the estate plan as a piece of the puzzle rather than a standalone chore.
Right, and it adds a layer of credibility. If your financial advisor, who you trust with your money, is recommending this platform, they've probably vetted it. It acts as a quality filter.
So let's bring this all together. We have a system that takes a complex, expensive, legally dense process and turns it into a 1-hour interview. It offers more privacy than a standard will by using a trust. It keeps your data secure with bank-level encryption, and it costs a fraction of the traditional route.
And crucially, it solves the ostrich problem. It removes the barriers of cost and complexity so people stop burying their heads in the sand and actually get it done.
But, and there is always a but in these deep dives, I noticed a little detail in the fine print regarding those unlimited updates.
Yes. The subscription model details.
It says you get unlimited changes and restatements with an active account. And it notes that data in accounts that have lapsed or been inactive for over a year may be archived and/or deleted.
That is a critical catch. In the old days, you walked out of the lawyer's office with a heavy binder. That binder sat on your shelf for 20 years. It didn't expire. It didn't get archived. You owned the paper.
Right. But here, your ability to modify the plan via the easy software depends on maintaining the relationship with the platform.
It does. Now, to be clear, once you print and sign the documents, they are legal. Even if the website disappears tomorrow, your signed physical trust on your desk is valid. The paper is the law.
Okay, that's a relief, so I'm not renting my will.
No, you own the document. But if you want to use the software to make changes, to add that new vacation home, or change a beneficiary, you need to keep the account active. If you let it lapse for 5 years and then try to log in, your data might be gone and you'd have to start over.
So it's a shift from owning a product to subscribing to a service.
It is. And honestly, considering how much laws and families change, a subscription model might actually be better. It encourages you to check in. The dusty binder method usually fails because nobody looks at it for 3 decades.
That's true. It forces us to rethink what a legacy is in the digital age.
It does. It's not a monument you build once, it's an account you manage.
So here's the thought I want to leave you with today. We used to treat estate planning like carving stone tablets. You did it once, it was heavy, and it lasted forever. But Claim Me Legacy is suggesting that estate planning is more like a garden.
A garden?
Yeah, it's something you have to tend to. You have to weed it when relationships change. You have to water it when you buy new assets. And yes, you might have to pay a gardener or a subscription fee to keep it healthy.
That's a great analogy. You can't just plant it and walk away for 40 years.
But it raises a question. If your credit card expires or you stop paying the subscription, does your digital legacy eventually fade away? It puts the responsibility back on you to stay engaged. The tools are easier than ever, but the responsibility to maintain them, that's still on you.
And perhaps that's a good thing. It keeps your legacy alive and current, rather than a relic of the past.
A fascinating shift in how we handle the end. Thanks for walking us through the fine print.
My pleasure. It's the most important paperwork you'll ever do.
And to our listener, thanks for taking the time to dive deep into something most people avoid. Maybe it's time to check on your own plan before the government steps in to do it for you. We'll catch you on the next Deep Dive.